Welcome. Glad you're here today. Yes, I have a mic on. No, you can't hear any projections. Apparently it's all for the camera. Sorry. Glad you're here. I'd like to introduce some of the players today. I am Ryan. Many of you I know, others I don't. Hope to get to know you. We have two other of our attorneys here. We have Michael, who will be up a little bit later to tell you about his story, and Amber, who will be following me, to tell you about her story. But we also have team. We have Paxton back there, who's helping make sure that I stay in a certain radius, apparently. Caleb here, getting the slides right, so hopefully we'll do that. And you've probably met two of the admin assistants already. We've got Heather on the corner and Carol, who you can love them, you just don't get to keep them. That's the key. So today, the design, as Michael's been wandering around, is to make sure that you're at the right seminar. But this seminar is designed to look about controlling from the grave. How do you do that, and is there any reason to do that? And as you can see, yes, you can. There's some really good ways to control from the grave, and so we're going to talk about that today. If you have been to one of our seminars before, you would know that we have purposes behind these seminars. And a lot of what we're doing is dispelling myths, that there are times people have heard things that you can or cannot do, which may or may not be true. So we will talk today about some of those myths. There may even be quizzes today. We may not have warned you about that. But you'll get to vote on a couple things. Second, we understand that everything we say today, even though all of you eventually will die, so it'll apply, but not all the principles apply to everybody. So these seminars are designed to help you, help yourself, or help your family, or help your friends. If you hear something today that you say, ooh, they need to hear that, check with the admin team. They can get you another copy of this. Give it away. As frequently as you'd like to, just give it away to other people that might need to hear about this also. A third one that we do is to be a resource to you. For some of you, you're new to our firm. For others, you've been with us for years. We also have an email newsletter we send out monthly that Amber is our editor on that. We try to come up with creative topics, like what can you learn about estate planning in a 30-minute drama? What did you learn from estate planning from Star Wars? Can you do a pet trust in Washington? And do you know the difference between cremation, aquamation, decompostation? All options. And so a lot of the resources we have are also on our website, which is being developed and reimagined by Paxton. So if you have suggestions, that's the gentleman to talk to today. Another one of the things that we do, if you're with us for a while, is we're here to be able to answer questions for you. If you've been with us, you know that I don't charge for emails, for phone calls, and questions. Why? Because if you call me with a 3-minute question, and it takes me 5 minutes to answer you, it's going to take 10 minutes to have my staff bill you for it, 20 minutes to take your angry phone call because you didn't want a bill for it, and 30 minutes to turn it over to collections on money you'll never pay. Answer the question. So if you have a question, please feel free. If we do not cover it during this meeting, feel free to email us. Always, if you've been with us a while, CC our administrative assistants because they'll be able to help you. But even during this seminar, we structure it in a way that if you have a question about something we're saying today, just raise your hand. If you're timid and shy, the way you start the question is, I have a friend who. We're good. We'll understand. So the first of the major questions was the title. Can you control from the grave? And people have been told all their lives, you cannot control from the grave. When you're dead, it's over. They lied. And so we'll talk about that. That's the whole purpose behind today, is to talk about how to do that. And if you go to the table of contents, you'll see we've covered quite a few unique things on here, and all three of us will have an opportunity to talk about different of these topics. But the reality is there are things you can do while you're alive to make sure that your goals are accomplished if you're incapacitated or dead. So just be aware there are things you can do. For many of you who've been a part of our firm, you have a good understanding of what is estate planning. For those of you that this is new, that we felt was the place to start. What is estate planning? Because it's more than just one item or two items. Estate planning is a series of tools that you use and are used for you either while you're alive or after your death. So estate planning while you're alive we'll talk about today, a financial power of attorney, a medical power of attorney, a directive to physician, and a HIPAA. When you're dead, we'll talk about issues of a will and a trust and the different things they do. We'll also touch briefly on estate taxes and incapacity. All things that might be important to you, but may not have the full information, or you just need a refresher. So those are a bit of what we're doing. What is the goal? Proper estate planning is you should get it done, get it signed, and be able to walk out the door and go, I am ready to die. Now, our record is 3 hours. We do not encourage you to beat it. Okay? But I will tell you that after I had that signed and I went back into the living room to talk to the two of the three boys, the other one was on a flight back home from a trip, two of the three boys, Mom had said, I just want to take my pain medicine, I want to take a nap, wake me up after lunch. And they thanked me, we got all done, got all signed, I left. I get back, we all have lunch, 1 o'clock, they turn on the phones and there's a machine. Mom just died. And the thing that they said, Mom had one more thing to do. And then she was done. Peace of mind, control. What we will talk about today in control is what documents do you want to use? Peace of mind is if you die, it'll go where you want it to go. So which documents and where's it going to go? That's what you're trying to accomplish. And you do plan it as if you're going to pass away right away. Because if you're alive, we want you to come in and review. In all of our newsletters, you'll hear us talk about reviewing a life event, a birth, a marriage or divorce, debilitating disease of you, a death of any of the players. If no major life events, then at least every 4 years, get it out, look at it, and ask yourself, what was I thinking? Make sure your goals haven't changed. But peace of mind and control is what this should give you. So when you go to page 6, we talk more about that. And we sort of say it in a fun kind of way. I want to be in control as long as I'm capable to be in control. When I'm not capable and control, I want to pick who's going to be in control to take care of me. And when I die, I want to pick who's going to be in control, who gets it. And when they get it, I want to be in control of how and when. Works for me. That's what you can do. Peace of mind and control. Who you put in charge is just as important as the tools you use. And the third item on that page is who the administrator would be. And there really are 4 categories. If you have kids, your kids. If you don't, other relatives. If you don't like your relatives, other friends who you wish were relatives. And last but not least, because we are the most expensive, professionals or corporate trustees. But it's very important you think that through about who is capable, who has the time, and we warn you, do not pick the smartest person you know. Because the smartest person you know thinks they can do it on their own. You want to pick someone who's smart enough to know they can get help. And we talk about a 3-legged stool. A CPA, a wealth advisor, and an estate planning attorney. All designed to help you, and if you're incapacitated, help the one in control, and if you die, help the one who's settling it. So choose carefully who you put in control. But this applies while you're alive. And when we talk about the issues of powers of attorney in a couple minutes, we'll talk about who you have down and who the successors are going to be for that. But that's on another slide. Another thing you're making sure is that the assets will go where you want them to go. That will involve also beneficiary designations. We were working with a young lady She had 2 kids, both adopted, single woman now. And she had an estate that about a third of it was her IRA. Her kids one was 20 when we started, one was 16 or 17. And then her house and her other assets. She came in to meet with her estate planning with me, and she said, I don't like who my son is dating. I think she's only after his money, and I'm not sure what's going to happen if they get married. My daughter, I don't have any idea about her choices. It's all over the board. I would like to put the estate in trust to them until they're about 40. We can give some along the way, but hopefully they'll get school done, career started, and figure out relationships. No problem. So we go to her IRA. This is a third of her estate. What are the beneficiaries? My kids. Whoops. So tell me, where did you get that information? Oh, my financial planner said, oh, you have kids. We can just put them down. I said, please, please, please. Go back to your financial planner. Ask her to say, to my estate. Because your daughter at 18 can walk in and cash hers out, and your son can cash his out right now. And she turns sort of a cute shade of white. And so she goes to talk to her financial planner. Before she can report back to me, I get an angry phone call. And my dad taught me a valuable lesson. When you get an angry phone call, and if you call me when you're angry, just be aware. Put it on speaker, let him yell, and get other work done. When they're done yelling, ask, are you ready to talk with me and listen to me? He wasn't. At one point in time, I got an interrupt because he breathed, and I said, do you know the age of her kids? His response was, why does that matter?
Oh.
She has since shifted who her financial planner would be. I said to him, once you check with the age of her kids, you call me back if you'd like to rediscuss this. But her whole estate is supposed to be in trust until they're at least 30. I never heard back from him. She shifted, and she since died, and the assets were protected. So making sure beneficiary designations on IRAs and life insurance and annuities and some bank accounts matches with what you're doing with your estate plan is very important. It all molds together so that it all goes in the direction you want it to go. Don't let it get distracted other ways. Other people's goals are to minimize estate taxes or to minimize attorney fees. Other people's goals is because every time someone has died and has gone through a probate, there's been World War III. And they wanted nothing in the court. They wanted privacy. But one of my more fun clients, he comes to see me. He's about to retire. And he said, and you know the difference between a will and a trust? We went through all the details, quoted him 2 different fees. He said, you noticed on my questionnaire, I'm retiring soon. Yep. In his case, the difference between that will and that trust is about $4,000. Yep. Guess what I'm doing for retirement? I hope you're taking a vacation. He goes, yes. And do you want to guess how much it is? It was nearly $4,000. He asked me, write this on your notes. I did not do a trust because I want you to work for your inheritance. He did a will. He still has a will. It's still in my notes. He didn't want to go to the time and the money now to set up a more advanced tool so they would have less to do when he died. Figure you're both getting over $1 million. You can put the money up to do this. You're determining what your goals are, and the tool you choose will help to make sure those goals are accomplished. That's what you're striving for. Peace of mind, control, when you do proper estate planning. And as you get that into place, all will be accomplished then. Now mind you, to see it accomplished, you'll have to be dead, but that's a different issue. So, question 2, what about if you're not dead? What about incapacity? Well, that's where we talked about the incapacity documents. Financial power of attorney, medical power of attorney, directive to physician, otherwise known as a living will, otherwise known as please unplug me. And last but not least, a HIPAA release, who has access to medical records. Those are the incapacity documents. We encourage everybody to make sure they have those documents. If any of you have a child who has turned 18 and they're still living in your house, kick them out. Or have them come do incapacity documents. Because if they're living in your house and they get in a car accident, you will be sued. If they go away to college, you'd think that's fine, they're out of my house. No, they get hurt over there, and without the right incapacity documents, you get no medical information and you can't help them financially. So any 18-year-old should have incapacity documents. It's your protection. Now, anybody in here babysit their grandkids? Got a couple of you? Yeah. Stop that. What in the world are you thinking? You don't get to babysit them until they get a financial power of attorney. Everybody is told, minor children, put the guardianship in your will. That's fine if you're dead. But more times than not, it's when you're babysitting and they hurt themselves. For instance, if the 5 or 6-year-old decides to hop on a bike because he's just learned how to ride, not thinking about the fact that the driveway goes straight down in the Twin Lakes Golf Course area, goes across a fairly busy street, hits a curb, launches over the juniper, lands on the ground, walks back in, and your brother-in-law is a football player about yay big and this size, and he calls you and goes, "Hey Ryan, where you at?" "You called me at home." "We're on the way to the hospital with your son." "Why?" "We think he broke his elbow." "Rolf, if I had a nickel or dime for every time he's hurt himself, I'll be rich." Upon which you said, "Ryan, I'm a football coach, was a football player, elbows do not turn that way." "Okay." So my sister takes him to the hospital, checks him in, they put him in a room, he's screaming a little bit. And in doing that, they go, "So what's your relationship to Alex?" "Oh, we're the aunt and the uncle." "Oh, where are the parents?" "Well, they're on their way. Will you please let us know when they get here?" "Okay, but what do we do about that?" "I'm sorry, I can't tell you anything." Without the power of attorney, more times a power of attorney is needed when someone's traveling or just out of the area and they need someone to take care of it. Now, for those of you that are my age or around that age, my mom and dad, they wrote the note. "Little Jimmy is over at Fred and Maryland's, and make sure you go get it, talk to them if something's going to happen." Yeah, completely illegal, and we've all done it. But the power of attorney is what you want to use. So make sure you encourage them to get that. There are some people who have a family history of incapacity. There are those who have genetic situations, they live till they're 90, but by the time they're in their 70, they no longer really know what they're doing. Anybody who's in that situation with proper estate planning will probably eventually have to do a court-appointed guardianship. That means you spend $10,000 to $20,000 to set it up, and you give account for every dime of the person you spend for as long as they're alive. Then you have to be excused by the court and approved of everything you did by the time they die. In that guardianship, the families I've worked with, none of them have finished the guardianship, got done with it, and said, "That was so much fun. How do you sign up for that again?" There are those who are predisposed toward incapacity, Parkinson's, debilitating diseases. If that is in your family line, instead of a will with death planning, you will want to at least explore the idea of a living trust, because that's a tool that is helped designed to protect against having to do a court-appointed guardianship. It's a very tough situation, but we've had families where it's happened as early as in their 70s, but I now have had one family that she was 47 and found out it was hereditary in their 50s, and sure enough, she was already getting loss of short-term memory. And she was going to be around for a long time. So they had to explore tools that met those needs. What are your needs? What are your goals? Looking at the different tools and what the different tools do is very important. But there's another issue about powers of attorney. On the financial ones, on the medical ones, always make sure you have an alternate. We got a call from a family situation. Mom is now incapacitated. They had done documents. They want to know what they can do now because the sister who was appointed is dead. The niece is now in a hospital because she's got some issues and she won't be getting out for a long, long time. There's no one left on the document and mom's incapacitated. That's a guardianship. They didn't have enough alternates on there. They didn't come update them. There are those who say powers of attorney expire. They actually do not, but there are institutions who are big enough that they say if a power of attorney is older than X number of years, we just won't honor it. Well, no, that's not legal, except then they say, well, we're not based out of Washington, so we can do what we want to do. And they get away with it. So Washington State put a law in place that said, if you take that power of attorney back to the attorney, if you can find them, have them do a certification that it is a valid power of attorney, and get that filed with the court, that brings it up to the current date. The cost of powers of attorney is something like $350. The cost to do that is several $1,000s. Being consistent on your powers of attorney, keeping them updated. Make sure your alternates. I met with a client this week. They were doing their review. It's been 5 years. And sure enough, one of them was dead, and the other sibling they don't talk to anymore. I'm going, good. So do we ask your dead parent or your sibling who hates you if we should unplug you? Ooh, tough discussion. But that's the reality of it. Make sure you do that. And by the way, on that page, right there, that was page 7. That's the one I talk about the temporary guardian and the powers of attorney if you have minor grandchildren. Yes, please.
I understand you saying have as many alternates as you possibly can. But if you don't have any in immediate family and you don't have friends or many friends
Or
that
friends you trust.
To do any of this stuff, I know you say, going to the lawyer as an alternate is expensive, but isn't that still better to do than not have anything?
Absolutely. All of that is better than nothing.
Okay.
Yeah, and we do that. I mean, we do act as trustee, personal representative, and power of attorney, but that's why I have an amazing staff. Okay, but yes, something is far better than nothing. And the other thing you'll learn is that the reason for putting multiple people down is because if I come to you as my sister, my brother-in-law, you're going to be more likely to say yes if you know you have an escape. Because my cousin over here is your backup. If you can't do it, say, look, I got to bow out, she'll take over. Because you have an escape route, they many times are more willing to say yes. Now, that's provided you talk with them, and not everybody does. So, do you have to talk with them? No. There's a lot of people that have been surprised. It happens. Healthcare power of attorney. People think, oh, it's a healthcare power of attorney. They can just make a medical decision. This document is really, really, really important. And from our perspective, we do not put that to financial and medical in the same document. Even if they're the same people, I don't do that. If you want to change your mind on one of them, then you got to change the whole document. Why do that? Plus, for my financial power of attorney, I want that penny pincher. I want that tightwad. I want the one who's managing the money and make sure it's all invested, doing well. When I do the medical power of attorney, I want that empathetic person. I want the one who will carry out my wishes. I want the one who will unplug me if that's my goals. I want the one who understands what I want for organ donation. Because you're to put that in your medical power of attorney. If you want it or don't want it, that goes in your medical power of attorney. So make sure with your powers of attorney, not only are they updated, but you have the people in there who will do what you want them to do. This is one I do encourage people to talk to. And I had a family, mom and dad, went to talk to their daughter who was going to be second in line for the medical power of attorney. Sitting in one of those kitchens that have the breakfast nook over here with the bench on it kind of thing. Sitting down, she's getting ready to serve him lunch. The daughter gets up, walks over, takes a piece of paper, scoops something up off the floor, takes it outside, flips it out, and comes back in. And says, I can just never kill them. Guess who's not on their medical power of attorney? They want to be unplugged. And they can just see that. Nope, I'll just take him home and plug him in because I can't do it. That's not their wishes. Make sure they're doing what your wishes are, not their wishes. Real important to keep that in mind. Okay? Directive to physician or living will. If you have done a power of attorney with anybody else for medical, please, please, please look at it. The medical power of attorney is where you say, I do or I do not have a directive to physician, and this person who's in charge of all of our medical issues, is in charge of this document. Every time you go to a hospital, they ask you, do you have a directed physician? Every time I say yes. Every time they ask, can I have a copy? I say no. Here's my medical power of attorney. This will solve everything. The directive is in their hands. The family that came to be clients of ours after the fact were in the room, dad's brain dead, they're ready to unplug him, they're getting pressure put on him from the hospital because it's in the middle of COVID, that they need the bed. The two kids are right there, and mom says, no, we're not unplugging him now. And the hospital put pressure on her to unplug him because they had the directed physician and said, these are his wishes. The two kids stepped up and said, no, get out of the room. There was a third child. He was traveling now to get to the hospital because their family pact was, everybody that can gets an opportunity to say goodbye before you unplug me. And yet they had to endure this because of a bad situation. All hospitals are not that way, but please be cautious. Your power of attorney for healthcare should control this document. Okay? We are not going to spend a lot of time on wills versus trusts right now, but the next page is a handout for those of you that want to understand a little bit more about the pluses and minuses to those. But specifically, the first one I want you to look at is the very first line. For those who know incapacity is happening, they look again to the fact that a revocable living trust is helping you to avoid a court-appointed guardianship, whereas a will is only death planning. So just be aware there's a difference, and if you want to explore that more, feel free. And as you can see, I'm going to get kicked out right now.
Thank you. Hello. I'm here really to talk about all things kind of beneficiary related, because everyone has different versions and different kind of variants of beneficiaries, whether it's minor children, adult children, it can vary. So what to do about your beneficiaries is a very important thing. In regards to that, the really next question would be, can you stop them from fighting? And truly, no, you truly can't. This will either be a time where things it's the last crack, last straw on the camel's back that breaks it, that ends up fighting World War III, or we have it and they come together and there's some camaraderie. However, if it's gonna happen, odds are it's gonna happen. What you can do though is be clear as possible. And with that, you wanna say who's getting it, how are they getting it, when are they getting it? Are they getting it all at once? Or are they getting it after they've attended college once they graduate as almost kind of a celebration point? There's all these different facets and different ways you can create trusts and other ways to have your beneficiaries receive inheritance. And so with that, you want to make sure that your documents are as very clear as possible, hitting those, how are they getting it, when are they getting it, who's handling it if they are not receiving it outright. Is it going to be in a trust for their benefit? Or, for example, if it's a child who has potentially maybe some alcohol and past drug problems, you want to be aware of that. It can plan for that. It can say you need to be clean. You need to have XYZ completed to be able to receive this distribution. But the most common one we see truly is all about moving into just for general beneficiaries, it's a mesh trust. That's maintenance, education, support, and health. It's very broad, and it's for that reason. We want to make sure they are intending to live the way that you would like, or this to supplement their life. It isn't technically, unless you want it to, unless that is your intent for this inheritance to be spread out for 20 to 70 years, for it to be their entire lifetime, you can do that. If you don't care and you just are like, hey, I would love you to get this and what you do with it is your own, then that's great too. It's really looking at who's getting it, because each beneficiary can have their own different provisions. You could have a minor child, and then you could also have potentially an older adult child that is getting a 10th, a 10th, a 10th, or a 10th, a 9th, an 8th. It's different. It's really up to you about how you want to subsect that. and ultimately looking at who the beneficiary is. And one beneficiary, or some that people don't think about, is our pets. Those are beneficiaries. They can be. As for me, I don't have children, but my fur baby is the closest thing to that. And so for that, I could set up so he is taken care of if something were to happen to me before he passes. And so there's really all these different things, and potentially for you, it might not be you're planning for your children so much, but maybe you're like, my children are doing great, I really want to focus on the grandchildren. And then we can focus on that. It's really just targeting who do you want to benefit from your estate. Here you go. And so with that, that's going to be really focused on the structure and moving the different things to your different provisions and details and things of that nature. And so what you really want to focus on is who's going to get it? How are they going to get there? Are they going to get it outright, or are we going to put it under a lock and key? Because if we're not certain about them, or maybe, they're great, we love them, but they married a spouse that I'm not certain of, we can put that under lock and key to make sure that it is there for your child's benefit, but it does not go to the spouse. So if something happens to your child, it could go down to the line, or it could go to whoever you would like next. So it's always thinking about, where does the diagram tree fall down? If this one person has it, great. Do you want your funds to be directed towards maybe potentially retirement? And then, okay, maybe the trust is there for maintenance, education, support, but they don't actually receive large chunks of the trust until retirement age. So there's different ways to look at it. It all depends on how you want to benefit your beneficiaries in that regard. Yeah.
So in hearing you say that, what if your beneficiary passes away?
Could you repeat
What?
that?
Yeah.
What happens to that money? Does it go back to the trust, or does it, if there's more than one child, is it divided between them?
So her question, that's a great question, was what happens if a beneficiary passes away? So if a beneficiary passes away, generally, and if you are working with our firm, we have what's called alternates. We have backups. We say, okay, what happens if this child's not here? Do we want it to go down to the grandchildren? Do we want it to go to the siblings? Do we want it to go to this charity? It is completely your choice. And so you can choose who gets it, how they get it, and who the alternates are to these things. It could be your pets, it could be the charities that are near and dear to your heart, it could be a good and trusted friend that's just really helped you out throughout life. It's whoever you want it to be, and so we would cater the documents to have backups to every different provision. Similar to the powers of attorney for healthcare and finance, how there's backups after that, we would do the same thing for your distributions.
So my B part.
Mm-hmm.
Can you say, upon my death, whatever goes to my estate? Just the estate, not naming one specific person? How wise is that?
So in regards to just naming the estate, your estate is what you have at your passing. So technically, if it's under your name and you have it when you pass, it is already a part of your estate. If you don't really care where it goes to, and you're saying, I have children, but I don't care if it gets to them, and I don't care if it gets to here, you could ultimately do nothing, truly, and you could just let the state has a formula and a diagram that it goes by, and it goes to the relatives that are closest to you. It goes the children, then the siblings, and then we have the parents, and it goes on the different levels. But if you want to have a say in it, you can. You very much can. You can plan for those provisions. You can plan for X, Y, and Z to happen. Or sometimes you're like, I don't know if they are going to have children, but if they do, I would love for it to go down there. And if they don't, then we'll give it to this charity. We can do it like that as well. And so during the initial IEPs and checkup appointments, we go through and we talk about that. We go through each step, okay, if this beneficiary is passed, what happens? And we do that with each and every single one. We always like to have kind of a 3-tier approach to it. But then ultimately, at the end of all of our documents, we have a final distribution. So if there is absolutely no one on the list that we wanted to give it to anymore, then it's going to go to this one final place, whether it's a family member or it's a charity and things like that. It's a catch-all. Okay? And so that is really just focusing on who the beneficiaries are, how old they are, where are they at in their life, because these things change too. You may have one that, college and in their 20s, it wasn't going too great for them, and it may have taken some time to really get on their feet. So maybe at that time you create a trust and you say, hey, I want their share to go here. I don't know who they're gonna marry or what they're gonna end up doing. I wanna make sure it's protected. Or as time goes on, they get a little older, they have a house, they start developing a family, they become more stable. You're like, you know what, I trust them. They can choose to do what they want with the money. I'm not worried about it. Or you might not care. It's really just thinking about what's important to you. Is it certain protections? Is it your peace of mind? Is it your beneficiary's peace of mind? It's really looking at those key things. Okay? And with that, I'm going to switch over to some estate taxes. So it's oh so fun. But with this, one thing that kind of ties in with the estate taxes are talk about how beneficiaries receive things. IRAs and things like that, when you, as Ryan said, when you name people, it goes directly to them. So you won't have that constraint of a trust and things like that. That is just one thing to think about, because otherwise you can have it directed to a trust. However, then there's some tax consequences to that. So it's kind of balancing what is important to you.
I just have one
Yeah.
question regarding IRAs,
Yeah.
beneficiaries and stuff. Let's say we have an IRA
Mm-hmm.
and I'm a beneficiary on his IRA, he's a beneficiary on my IRA, and if we do an estate plan, a trust, do we need to change that, the beneficiaries to the trust instead?
You may not want to. Generally, we say IRAs and things like that are better off going to a person versus an entity, and that's what a trust is. So you would get hit with a higher tax hit when the trust has to pull that amount, whereas an individual has a 10-year span to pull that out, and it's based off their income tax bracket. So that's where that changes. But if the protections of a trust are more important to you, that's when you would put the trust first.
The first half of the question being to the spouse. The spouse has still a lifetime rollover. So most cases when it is spousal, unless it's an inherited IRA or an IRA you brought into the marriage, you would normally make your spouse first so they can turn it into their own IRA. And the second half is everything she said. We first, before we make any recommendations on retirement accounts, is to go through, if you both died, what happens to everything else? As she mentioned, the Secure Act is what's messing everything up. For my boys, we're now 35 and 32, we're not giving it to them for their whole lifetime. It's staying in trust for their whole lifetime on everything else in our estate. We had a choice. Do we make them the beneficiaries of the IRA? Well, if we do, we have no control over it. They get it the first 10 years. So we have to decide the best income tax protection or the best beneficiary protection. The other part of that is we've had some very creative clients. Of our IRAs, they're the second beneficiaries. They'll have the first 10 years. Of everything else we have, that'll start going out after 10 years. So you look not only at the value, you look at the beneficiaries, and then you have to fight the IRS between income tax versus distributions. The Secure Act has really messed things up a bit more than it was before. But that one's definite. If you have an IRA, and everybody calls a large IRA something different, dollar amount, make sure you talk with us about that.
And then Michael will be taking over.
Well, I'm here, as you can see from the screen, to talk to you about state and federal estate taxes, which means I drew the short straw, and they got the fun topics, and they stuck me with taxes. So now that's when I direct the staff here to lock the doors and keep you in your seats so you don't know when bolts and starts running away. I kid, because I know as I previewed the audience here, there's a few tax questions in the group, so I know there's some folks actually interested in this. So those of you who want to have your eyes glaze over, I'm used to it, it's okay. This is actually an area where we've had a lot of changes in the last, week, and I don't kid when I say that. If you've been following and getting our newsletter and getting materials from us, we've been telling you about tax changes since last summer, if not before last summer. But everything we told you, a lot of it changed last week in Olympia when the legislative window here closed. They were passing legislation on that very last day that said, you remember everything we did last year? About that. We've had some second thoughts. So I'm here to kind of clarify the mud and give you a little better of an idea of what you face right now. So we describe estate taxes as the limbo bar. Everyone remember the limbo game? Try to duck under the bar. If you can get underneath it, you pass to the next round. Well, the limbo bar in our world here is, what is our estate tax exemption? How much will the government allow you to have before they start to tax you? We have two limbo bars that we pay attention to. We start with the federal limbo bar. That's the one that's the highest, easiest to get under. Anyone know what the federal limit is right now? Kind of quiz the audience. 15, okay, well, geez. There goes the surprise. All right, well, at least you're paying attention. So 15 million is our upper level limbo bar. A lot of more people can get underneath that one. Right now, Washington is at this peculiar number, it rolls right off the tongue, $3,076,000. And that is going to be our number until July 1st. And that was our number beginning January 1st. And you're like, well, wait a second, that doesn't make any sense. Welcome to the changes that happened literally 8 days ago. Since I wrote this down here because I can't ever remember how long we had these things in place. We were stuck in Washington at $2.193 million, another number that rolls right off the tongue. We were stuck there since 2018. And our legislature just allowed that to kind of freeze in place and be our rule until they came back and they said, you know what, we're gonna raise the limbo stick. We're gonna raise it up to 3 million. And we're gonna adjust it every year because of inflation. So 3 million became the law last July 1st. And January, they didn't announce it in January. It took them a while to get the numbers to do the inflation calculation, but then they raised it up to $3,076,000. Well, okay, well, great. That's the way the law was written. Well, when they put that law in effect, they said, oh yeah, and the tax rates that used to be from 10 to 20% are going to now go from 10 to 35%. And a lot of people went, wait a minute. I like that you raised the limbo bar, but did you have to raise the tax rates too? So a lot of people complained, reached out to their legislators, and those legislators came back to Olympia this year and said, hey, maybe we went a little too far, a little too fast. And so we're going to redo this, hit the reset button. And so their new law, which takes effect this coming July 1st, is going to now say this limbo bar goes back down to 3. But the tax rates go back down to where they used to be, 10 to 20. So we're going to reset that. Now, what's going to happen with this number moving forward? Well, July 1st goes back to 3 million, but every January they're still going to adjust it for inflation. But they've changed the measuring stick that we use to calculate inflation. They have all these guides based on what's the standard of living cost in these different cities. And they were using a Seattle-based metric. And so now they're going to do a blend that's going to have Seattle, Bremerton, Tacoma. It's going to be a little bit more encompassing of what the totality of the state is facing, not just the Seattle metropolitan area. So we may not see real big jumps in that adjustment here moving forward, but that's something to pay attention to.
What about the rate?
The rate was reset, and that goes July 1st. It goes back down from the 10 to 20 range.
And when they do this calculation for inflation, are they going to keep it?
It's supposed to stay at that rate. If they're going to adjust it, it's going to have to go back through the legislature, okay? Now, my crystal ball is probably as good as yours. I don't know what they're going to do in the future. But with the backlash that they got and the fact that they reset it so quickly, I don't think they're going to be so quick to hit that button again. Yes?
I don't know how this works. So is the estate tax anything, it's taxing anything over this $3 million?
You got it.
Okay, so if someone has less than $3 million, then they don't get it.
You got it perfectly. Yeah.
Okay.
So the question was, I'm not sure if I have this, but if we're over the 3 million, I get taxed, right? Yes. If I'm under, I don't get taxed. Correct. She had it perfectly. Question over here.
So over the 3 million, you've mentioned 10 and 20%.
Yes.
Where do those, it cuts in over 3 million, but where's the break to, from 10 then?
Okay.
To 20?
Yeah. So the way our tax system is structured is it is a tiered system. So the first $1 million over our limbo bar. Okay, so if you have a $4 million estate, that $1 million that's over, that's the only piece that's going to be taxed. That gets taxed at 10%. The next million, if we go over that, that second million gets taxed at 14%. The first million still taxed at 10%. So now we're kind of doing these different little chunks, and we're going to add it all up at the end to figure out what the total amount of tax is. So each segment that we move here, only that portion goes up higher. You're still being taxed 10% on the first million. It's a mess, isn't it? But the more you know, the better you can plan. All right. So as the slide says here, this is a privilege. The estate tax is a privilege that you get to have here for transferring your assets the way you want to those folks after you're gone. And so this is the state's way to kind of collect a little bit of revenue from people during the process. Now, that's the base level that you need to understand. Is that the final matter on this? No. Because with proper planning, we can avoid a good piece of this, maybe entirely, depending on what your situation is. So let's go to the next slide here. Other key things to remember about estate taxes, there are time limits involved. If you fall into a category where you or an estate you're involved with has an estate tax problem, that tax will need to be paid within 9 months of that person passing away. And there's a tax return that goes to the Department of Revenue here in Washington. And when you submit that, they say, yep, you got to pay us the tax as well. And there's some rules around that. There's some times to get extensions as needed, but it's best to make sure that you, your loved ones, are prepared to figure out how is that going to get paid here in that 9-month window of time. Sometimes that becomes what we call a liquidity issue. Do I have enough resources to be able to write that check? And sometimes that's a wake-up call. And that can cause panic and cause people to do a fire sale of assets to try to raise money if they don't have the resources to make that available right away. The big question I always get is, well, they don't count the house when they calculate what the taxes are, right? Yeah, they do. Well, I have life insurance, but that doesn't get taxed at all, right? Yeah, it does. Well, what about all the silver that I've got stashed in the drawers? That too. Yeah, the state of Washington wants to know where everything is and what's the value on it. And they want to know what that date of death value is too. That's the measuring stick we use. So that way, if you've got a piece of property as part of the estate, our advice is always going to be, well, let's go get someone who knows how to value real estate. Let's get an appraiser to come out and give us a fair market value of what that property is so we can figure out where are we actually going to fall on this tax scale. Because if we don't tell them a number, the state of Washington might come back and say, yeah, that's not a fair, accurate value of the real estate. But if we're armed with an appraisal, well, we've got a pretty good bullet in our chamber here to say, no, we paid good money for this appraisal. We stand by this value. This is done. This is not just a made-up number here. We didn't get it from Zillow. We didn't get it from Redfin. We have substantiation behind that. All right. The other thing to remember is, question in the back.
Well, when you're saying to get fair market value on a home, you wouldn't call up your neighbor who happens to be a real estate agent and say, hey, so there is specific companies that are estate appraisers, so to speak? Real estate appraisers?
Yeah. So the question is, if we're trying to get this valuation, would we call our neighbor who's in real estate, or do we go to someone who's doing appraisals for a different purpose?
Yeah.
I get this question a lot, and sometimes people will say, well, my friend's in real estate, and they do what's called a market analysis or a comparative value, like you might do for, hey, we're going to try to list the property for sale. That's not quite the same standard that an appraiser works by. And so we're always going to try to err on the side of getting the appraisal done because it's a little bit stronger substantiation for the estate to rely on, for an accountant to rely on. If we're going to go toe-to-toe with any kind of a taxing authority in a dispute about value, we want to make sure we're going in with the best information available. So yes, there are ways that those reports can be different, and we would try to make sure that the appraisal is what we get. Great question.
Do you guys have a list of preferred appraisers?
We will always be able to put you in touch with folks we've worked with, that we've got a good relationship with, who do good work. Yes. Yes. If you ever need assistance with anybody, we try to maintain a list of those folks who have done really good work for our clients. Yeah. Thank you for that. All right. The last item here I wanted to talk about is, as we're looking at this today, and you might say, well, my estate is worth $2.9 million. I'm good. I don't have to worry about this. This is not my issue. Well, sometimes you forget that our real estate values typically keep creeping up. At least hopefully they are, right? And that the account in the stock market, we'd like to see that number go up as well, better than the other direction. So our point here is that we tend to see that the value of your estate appreciates over time. $3 million is a good number to have in your head. But I would say as you get close to that number, don't wait to hit that number. As you get close, reach out and start talking to someone in our office here about what that strategy might mean for you. There are ways to put tools in place to be proactive rather than reactive to the situation. Because again, we don't know what our future is going to be. We don't know when our time is up. I'd rather be prepared and have the right tool in place. So, what can we do? Oh, before we go on to that, yes, question.
How do they know about your assets, like silverware? How does that even get?
Yeah, if you've ever looked at the estate tax return that the Department of Revenue wants filled out, it's pretty comprehensive. And we don't do those internally. We always get a CPA to help out with that because that's really their area of expertise. But they have a whole slew of categories that they want filled out, plus a substantiation behind it as to how it was calculated. If we're saying we've got X number of dollars in the bank, we're going to have a statement that verifies it. Same with other financial accounts. When it comes down to some of the household items, yes, it's a little harder to have some of that documentation, but depending on what the asset is, if it's collectible, if it is something that's a precious metal, we can make sure that we have someone who has looked at it, weighed the silver, weighed the gold, and told us what the market rate was as of the day that person passed away, and that would be substantiating evidence that we would use as part of that.
Someone has to declare that they actually had that.
Yes.
Right? So if you don't declare,
Well, you're talking to an attorney, so we're always going to talk to you about, let's be honest, and let's make sure that we're not hiding anything. That's always going to be the party line here. But I appreciate the thought. Yes? In the back, did you have a question?
Yeah, so based on your scenario, let's say you inherit $4 million cash, and you got a house that was purchased at $500,000, and then now it's worth $1 million.
Okay.
So
4 plus 1 is 5. I'm good on math so far. Let's keep it simple for me.
so between 3 and 4, you pay the 10%, right?
Yes.
Tax. Now, for the house is valued at $1 million, you're gonna have to step up basis to take care of that, so you don't have to pay capital gain, but you still have to pay 14% on tax. Am I correct? If I sell the house.
This is an excellent question. So let me try to rephrase it so everyone in the room could hear it. The hypothetical that you're throwing out at me is you have an estate worth $4 million in cash with a real estate property worth another $1 million. If you passed away with a total of a $5 million estate, the first 3 is protected. The first $1 million taxed at the 10%, the second $1 million taxed at 14%. Okay, so that's sort of a repetition of what we were explaining a few minutes ago. But the gentleman brought up a question here about, well, if the property is part of the estate, does it get what's called a step up in basis? And so now I appreciate this because you're allowing us to introduce another tax equation here to the mix. There's multiple ways that the government will try to tax you. So we've got the estate tax and then the capital gains tax, which is a separate matter. The capital gains tax will only come into the picture if you, like you said, if you sell that property, okay? And if it's sold shortly after someone's death, what you're saying here is that basis is stepped up to that fair market value as of the date of death. That's why we get that appraisal, so we know what that value is. And maybe we're selling it where there's no gain that's subject to that capital gains tax. But that's sort of a compounded problem on what's our estate tax issue. So we try to make sure that we're cognizant of both of those areas and able to advise you on what that situation looks like in everyone's particular situation. So as the question throws out here, it's not always just one factor that we've got to pay attention to. There's usually a few things to pay attention to. Did I answer your question? Okay.
That mill would still have to pay 14%.
On that, yes. If it's $2 million over, yeah, you're going to have the 10% and the 14%. So a $240,000 tax bill is potential there.
Do the step up.
Oh, okay.
Step up because he did kill someone off.
All right. So, this is where normally I have a whiteboard. The strong teacher instinct in me likes to map things out visually for you. So I don't have a slide on this one. So follow along with me here. When you buy an asset like a house or a stock, that purchase price is what we call your basis in that asset. And as time goes on, we hopefully see that value of that asset grow. If we sell it at this value and we started here, well, the difference between my hands is the amount of gain that you have realized during your time period owning that asset. That gain goes into an equation and it results in a computation of what your capital gain is. So your house or stock is a capital asset. The gain is what's being taxed at the time it's sold. If you pass away owning that asset, you didn't sell it. So now what we do is, with an appraisal or a date of death valuation, we now move the basis to that point. We're stepping up that basis to that current value, sort of resetting the clock. So now as that asset continues on, if we're passing that asset down to our kids or someone else, we've wiped out a huge chunk of potential capital gains taxes for them by allowing them to inherit that asset. And when we reset it with that step-up basis, we're trying to do the same thing again for a future generation. Yes?
Does that work for businesses too, like real estate businesses?
Yes, largely it will. It's always going to be a factor of what is the asset that's involved. So yes. Yes, sir.
Involved with it. So what happened if you do a 1031? Can it push it down forward? Or you cannot do that at 1031?
At what time are you doing the 1031? During your lifetime or after someone's passed? Or
Pass, I decide, okay, I don't want that house, I want to sell it.
yeah, I don't know that you would need.
1031, so it will push it later. Do I still have to pay the state tax on that?
No, I don't think so, because I mean, what we're dealing with here is when we've got that stepped up value, if you're trying to sell the house, you just go ahead and sell the house. The 1031 is usually involved to try to keep rolling over the growth that you've had and avoiding tax on it. So if you're getting a sale done right after the death, it's less of a factor. You wouldn't necessarily need that 1031 exchange. Yeah, I'm sorry, you had a question earlier and I got sidetracked. I apologize.
This is real life.
Yeah.
I have a stepmother who passed away March 27th,
Okay.
2025.
Okay.
In 2002, I think it was, she put my sister and I on as owners in the house with her.
Okay.
She thought that was a good idea. She thought it through. She talked with whoever. We just said, okay. So when she passed away, we owned the house, cold turkey. We could do what we wanted to it. We were the owners.
True.
we sold the house in July. And this is all New York State tax issue.
Okay.
But if you could give me, if that happened here in Washington State, what are the tax implications for my sister and I and her estate?
Okay. So let me try to rephrase the question here to make sure everyone in the back heard. What happens when you have a parent who adds children onto the title of the property while they're alive, and then they have the nerve of passing away a few years later? And what kind of tax impact does that have? Okay, so we're going to look at that from a couple of different tax lenses. While we've just been talking about basis, let's start there with capital gains tax issues. When we make a gift of property during our lifetime to somebody else, we're giving them the asset, we're also giving them our basis. So what I bought the property for is now your basis if I gave you an interest in that home. And so that means that you're probably going to be subject to some capital gains taxes if you decide to sell that house a few years later. You're not going to get the benefit of having the estate step up the value because I passed.
So the basis would be 2002 when she put us on the title.
The basis would be what she paid for it when she bought the house.
Well, that goes back,
Yeah,
she was a stepmother.
yeah. So
So
that's,
she-
this is one of the, we're gonna have a slide here in a moment here about gifting. And that's one of the big things to keep in mind. When we're giving assets, we give basis with it. And so it may be great because we're getting an asset out of our name if we're trying to manage the size of our estate. But while we may be avoiding estate taxes by doing that or limiting estate taxes, we may be giving away an asset that's going to have its own capital gains tax issue. And so there's always a decision that needs to be made in terms of what are we trying to accomplish and whose benefit are we looking out for, ours or someone else's. Now, the other part of the tax question in your scenario here is, what was her interest when she passed, and what was the total value of her estate? There could be estate tax issues. I don't know New York laws, even though I'm from New York.
She's below everything.
But if it was in Washington, we'd be paying attention to that $3 million valuation if it was a death occurring, recently. But you said it was a couple years ago when it went a $2.193 million exemption that we pay attention to. So I show you the steps that we kind of go through when we analyze these things to figure out what rule applies at what time. And that's why it's really important that you stay connected to someone who's paying attention to this stuff so we can help you figure out what is it going to be in your particular situation. Because when you have the tax laws changing practically every 6 months right now in Washington, it really is splitting hairs to figure out what rule applies to you at this particular slice of time. Did I hear a question? Here.
What is the capital gains tax rate now, like if I should sell my house and?
That's not a number I keep in my head. Do you happen to know?
23?
The guess is 23%. That's a number I will always defer to the accountant because sometimes they play games and figure out different ways to calculate some of those things, and that's not my area.
Okay.
That's one of the other legs of the stool here, the accountant, the financial planner, and the estate attorney.
Got it.
All right. So let's dive into what can we do. We've touched on some of these things here before, but I want to make sure I give you the value of everything we wanted to give you today. So let's make sure we talk about all of this. We're going to keep our numbers nice and simple because math is not the thing I want to do in front of an audience live and in person. So we're going to use nice round numbers of 3 million for today's purposes in preview of what we're going to get as of July 1st again. So our couple here, you might be familiar with them. It's Ward and June. They live in Mayfield. They've got 2 kids, Wallace and Theodore.
Yeah.
You know, the Beeve.
Beavers.
That's right. So if we have a $6 million estate between them because of all of those TV royalties dating back to the 50s, if they did nothing special and they just sort of had the traditional, I love you, honey plan, I'm going to give you everything, we run into a potential tax problem in their estate. So we live in Washington, we're a community property state. That $6 million overall is going to roughly be $3 million his and $3 million hers. And so The good thing to know is that in Washington, you can give as much money as you want to your spouse, and none of it is going to be subject to estate taxes. It's this unlimited marital deduction that we have. Hundreds of millions of dollars can flow back. Wouldn't that be a great problem to have? Sounds almost like a TV show. But you know, it would be a great problem to have. But it's a matter of how we do our planning, okay? So we're going to show you the sort of the worst case scenario, if we can call a $6 million estate the worst case scenario. The will just says, I'm giving it all to my spouse. We don't know who's going to go first, Ward or June, but you know, we'll pick on Ward. So if Ward goes first, everything goes to June, and now she's got $6 million in her name. When she passes, what's going to happen? Think back to the limbo bar. Estate taxes, because we're over the limbo bar by how much? $3 million. Good, you guys have been paying attention. I love this. All right, what's the math going to be? The first million's taxed at 10%. The next million taxed at 14. The next million taxed at, I didn't give you this information. I'm just looking to see who knows. 15. So $390,000 tax bill in this situation that Wally and the Beaver are going to have to come up with when it gets passed down to them. I say it's going to be the kids' problem, not the parents' problem, because they can pass as much as they want back and forth. The estate tax is going to hit when we get it down to the kids, to that next generation. So that's not swell. Let's figure out how we can change that. So let's move to the next slide here. This is more of the tax-wise plan. Now this can be done in either a will or a trust. So Ryan alluded to it earlier. He had that slide as part of his materials. It's in your handout. How do I do a will versus trust? Well, the good news is either one of those approaches will give you the tool here to start saving on the estate tax. So we're still in this situation with Ward and June. It's still a $6 million total estate. We're still going to give them each $3 million. But when Ward passes, his estate or his portion of the estate is not going to go directly to June. We see it passing down into something we're calling the family trust. You might have heard this by other names, like a credit shelter trust, a bypass trust. These terms all mean roughly the same thing, but we're going to use family trust. And June gets the benefit of all of the income and the principal of that family trust as necessary. The income's going to come out every year. We don't want trusts paying income taxes. We'd rather June pay the income tax. Her rate is lower than the trust. That's why. But what do we do here in terms of principal? Well, if she needs it, if she starts running low on cash from her $3 million that's in her name, she has access to it as needed for, like Amber said earlier, maintenance, education, support, and health. Those same standards apply in this situation as well. But the real magic of what we've done here by using this type of a structure is when Ward passed, we're using his $3 million exemption. No tax on that because we're using this tool. And so when June passes, we're only worried about what's the value of her estate. And so she gets her own $3 million exemption. So by using careful planning, we can each take their exemptions and stack them together, and we've protected the whole $6 million of TV royalties. Yes, in the back.
Okay, it says will or trust, but this seems like it's will and trust. So after he dies, then he gets a trust.
That is a very good observation, yes. Earlier I said we could use this technique if you had a will-based plan or a trust-based plan. But your observation is exactly right, that we are creating a trust in either one of those plans. So it's sort of a secondary trust. So if you did a trust-based plan, this would be a brand new trust that gets established after Ward's death. If you did it in a will, the will says, at the time of my death, create a trust. And that's going to be the same type of trust. So if it was a will-based plan, you're exactly right. It's a will and a trust. Great observation. Not everyone catches that. Thank you.
But if your assets are less than $3 million, even with the two together, you don't have to worry about any of this.
Correct. If you're not at that near that 3 million mark, this may not be the number one concern you have in your estate. This is really just kind of outlining the other areas that we pay attention to because everyone comes to us with a different set of priorities. And some will be focused on this and some will have other priorities. So thank you for clarifying that with me. Yes, sir.
So clarify, so when June dies, the funds that are in the family trust, which are for her mesh support,
Yes.
how are they dealt with from a tax basis?
Let's start from the estate tax basis. Okay, so, and the question here for those in the back here is when Ward passes, he's putting his funds into this family trust, and June gets the benefit of it while she's alive, but what happens after she passes? What do we do with this trust? Which is a great question. Well, it's all going to go back to, well, what did Ward want us to do with that money? Because this trust is designed to protect his estate planning goals. If he said, take care of Wally and the Beeve, then when June passes, anything left over here is going to get passed down to that generation. Now, because we funded this family trust at the exemption level, $3 million, all of that is sheltered from estate tax. Now, let's say if that money was put in there and June didn't need it and it was invested wisely and it grew, it's still sheltered from estate taxes because that's the deal we made with the government and the taxing authorities by using this type of a tool. So not only can we protect the $3 million exemption amount, but we're sheltering the growth that could potentially happen in there as well. So the Wally and the Beef might end up getting a bigger payday that is free of estate taxes by using this technique.
Oh, I have another question.
Yes.
So if you do the trust before you die and you put 3 million, like almost 3 million in there, and then it grows, is it also, is it still protected, that $3 million protected? I mean, can it grow and still be protected from tax?
That's a great question, and I'm going to key in on one of the phrases you used. If I do this before I die, and that's the key part, it's important that we have this type of a plan built in to whatever plan you've created. If you have a will or a trust and you're aware that you're near this $3 million mark and estate tax is a concern, your document needs to have that tool in it. But we're not funding this trust while you're alive. This is going to happen after the first person passes away. So this is a tool that we use for married couples. This is a tool that we get to use for that purpose.
So that doesn't work for a single person?
No, this is not going to work for a single person. We'll talk about some other strategies here in a moment. Yes, sir.
So did you say there has to be verbiage in the original trust document that you're going to form this family trust?
Correct.
Okay.
Yeah, both of us have to be alive, and we have to agree that we're going to build this tool into our plan, so we're looking out for each other, and it's not just the I love you honey plan. It's the I love you honey, but I want to make sure I use my exemption. Yes?
What if all or most of my money is all going to charity? No family members, no friends, no anything?
Great question. Okay, so what do we do if we've got an estate of a certain size where taxes might be an issue, but we're not leaving it to friends or family, we're leaving it to mostly to charitable organizations? That charitable organization donation or distribution will serve as a deduction against any estate taxes. So it might wipe out the estate tax bill that could otherwise have been there. And so we're going to talk about that in a moment as one of our ways of reducing or avoiding estate taxes is the use of charitable giving. Fantastic. It's like you read the materials here and you were anticipating that. Any questions on this? I think you guys have it. You guys were giving me all the details here as we went along. I love it. It makes my old teacher heart sing. All right, let's move on to yes, go ahead.
So Wally and the Beeve will get the family trust.
Yes.
June passes.
Correct.
But her assets can also go straight to them, and as long as it's under 3, they're not going to get hit with that either.
Isn't that a great day for the Wally and the Beeve? Yeah. They're basically going to get 2 inheritances, one from this pocket and one from that pocket, and it's a pretty good day for them. Now, if they could just keep Eddie Haskell at bay, because you know he's knocking on the door the very next day. All right, let's move on to the next slide here. So,
talk to the right folks.
Yeah. We have to make sure our material is gauged for the right room. Amber, I'll tell you later what that all means. All right, So some of our ways of avoiding estate taxes, like what can you do? That trust that we were talking about here is a way of controlling the issue, even though we've gone. So that is the theme here. How do we control from beyond the grave? Is we set these things up in advance. Other times we're looking at other strategies, and this might apply for those folks who are not married. We might need to use some of these tools to help bring down a potential estate tax. So one of our strategies here is just make an outright gift while you're alive. Just start giving cash to charities or friends or family or whoever you want to leave it to. There is an annual gift exemption. If you are giving $19,000 or less per recipient, you can start to get yourself out of this tax problem. If you're married, you can each be making a $19,000 gift to as many people as you want. It depends on how generous you are, how charitable you want to be. Now, when I throw that out there, some people start to assume, well, if I give 20, that's more than 19, am I being taxed on that? Are they being taxed on that? And the answer is no. It's a paperwork requirement that we have when we get above 19. If we're being really generous in 1 year and we make a larger gift than $19,000, we need to fill out something on our next personal income tax return with the government that said, I was really generous this year and I gave my son and I gave my daughter $25,000 each. And now I'm starting to dip into my lifetime giving exemption, which is tied to that federal estate tax limbo bar. Anyone remember what that was? 15. Gosh, this is a great crowd. So we have a paperwork requirement just to see how much of that lifetime giving exemption have we used up. And so if we're not near 15, well, that's not a huge worry, but we want to keep track of that paperwork-wise.
But
So
you
that
don't
is...
have to- You don't have to fill out that paperwork for the IRS if you're under the,
Correct.
nothing, they don't.
Correct.
Nope.
You're making $1,000 here, $1,000 there, no paperwork, nothing that you have to worry about. Yeah, this is only when you start to get above that 19,000. And that number changes periodically, so check with your accountant or check in with us if you're questioning, hey, has it gone up? I want to be more generous this year. Have they changed that level? And we can fill you in. They usually reset that every January 1st.
And the person that receives the gift, they don't have to,
Correct. They're just receiving your generous gift to them, and they didn't earn it, so they don't have any income tax on it. It's just flat out money in their pocket or their bank account. All right.
Excuse me, it's a joint gift from husband and spouse to a son, for example, and it's over, it is 20,000 more than 20. Do you need a tax return in that case?
No, because in that situation, what you're probably doing is coordinating your giving and saying, I'm going to give 10 if you give 10, and now our son or daughter gets 20, but you haven't exceeded the exemption because you're each using only a portion of your gifting level. Yeah, that's good. That's a good question there. Other questions? I thought I saw another hand. Okay. Now, sometimes these gifts are things that we're doing while we're alive, and we're just being very generous, and we're just trying to get our estate value down. And we're doing this over a period of years to make sure that we're managing what our overall estate looks like. Sometimes we might be doing these gifts as part of our will or part of our trust, and we might be putting strings on that gift to say, well, I want you to have this, but I don't want you to have it now. And that's a future gift. Well, that future gift doesn't qualify for this $19,000 I'm talking about, the annual gift, unless I give you the ability to use it now if you wanted to. Now, this doesn't always make sense the first time you hear it, so let's break this down. All right. I'm going to give you, I'm going to put $25,000 aside for you. I'm going to put it in this trust over here. It's for your benefit. You'll get it someday after I'm gone. But I really want to start using up some of my gifting, but I don't want to use all of my 15 million lifetime giving. I want to use that annual exemption. In order to use that annual exemption, I have to give you a window of time to say, hey, I've put this money aside, it's for you. I really don't want you to touch it right now. I'd really like you to use it in the future. But if you are aware you could use it and you decide not to, then I get to use part of my annual giving on that. And that's helpful. It's just another form of leverage of getting more money out of my estate. It's called a crummy power because of a case that went before the Supreme Court or the Taxeth Court, and that was one of the parties' names. Not because it's a lousy thing. So it's not that kind of crummy. So that may be more than you need for today's purposes, but just know that these are tools that we have available to us to figure out what is the right approach depending on what kind of goal you're setting for yourself. If gifting is an important strategy to you, we look at it from a couple of different lenses as to how to maximize your giving, depending on how aggressively you want to bring down the value of your estate. The next item here, using limited partnerships or limited liability companies. Sometimes we might be blessed with owning some real estate or a building or something like that that's generating some good income for us and might have a significant value, and we're worried about, well, I don't want all of that value in my estate because it's going to trigger estate taxes. So maybe I put that building into an LLC, a limited liability company. And maybe I've got a couple of kids and I want them to go into business with me, and now they become members of that LLC with me. And I'm starting to transfer ownership of this building over time so that I own less and they own more, so that I can bring the value of my estate down. These are some other strategies that are available depending on what we're trying to accomplish. We're not going to go into a ton of detail, but just know that these things exist, because again, everyone's situation is going to be a little bit different. Crummy trust is what I was talking about there a moment ago, house trusts. We will occasionally get folks coming in and saying, I've got this really valuable house and I'd like to get it out of my estate. I heard I could put it in a trust and my kids will get it, and that gets out of my name, and now it's all the kids' problem to deal with, but I want to keep living there. Okay, we can work that out. You just have to make sure that we set a time period for this trust. It's called a qualified personal residence trust, and we attorneys love to abbreviate everything, so we abbreviate it with an acronym, a QPERT. Wasn't that a game in the 80s? Oh, no way, that was a different game. QBERT, okay. So when we set up these QPERT trusts for real estate, we just need to make sure you live long enough. And then we can get it out of your estate, it gets to the kids, and win-win. Now we're dealing with other tax issues there, but there's a tool for every goal that you're trying to accomplish. You just need to sit down with someone, walk through what you're trying to accomplish, and we help you evaluate what's the best tool available to help you get to the finish line that you've set for yourself and your family. All right, the last question here when you're talking about controlling something from the grave is, well, I'm not here to do it. Who's going to do this for me? And Ryan touched on this a little bit earlier at the very beginning here, but I think it's important to kind of come back to this point. We want someone who is strong and handsome and Viking or a Norse. Well, okay, maybe not. But we do want Thor, if we look at what Thor stands for. We want someone who has the time to take this on, or is the appropriate person at the time we need to put this into place. We want someone who is honest, organized, and responsible. So that's really going to be our checklist here, figuring out, who in your world checks those boxes to be the person that we can trust to get the job done when we need them to, because we won't be around anymore to nag them or correct them to do the right thing. So that choice usually boils down to, do I have an individual in my life? Do I have a family member? Do I have extended family or a trusted friend? We usually go through that order. We want to make sure that it's someone we know really well, that we have a lot of trust and confidence is going to do the right thing. Sort of understands what we're getting at, what our goals are, and how we're going to accomplish that. Family conflict is something you need to be aware of. I've sat down with numerous people and they say, well, I'm just going to put my kids in charge of this. Okay, well, how do the kids get along? They don't speak to each other. Okay? And we think that they're going to all of a sudden magically sing Kumbaya together after you're gone and get this all figured out? Oh, no, I guess we're not going to do that. Okay, so let's rethink this. Is one sibling going to treat the other one fairly? What's the source of the conflict? We try to dig into that to figure out if that's even a good, viable option for you. Sometimes we just rule it out. What's plan B? Is there someone else, sort of a neutral party? Maybe it's your favorite uncle or your cousin who can come in and kind of just say, knock it off, knuckleheads. We're going to do it this way because that's what they said we're supposed to do. Just everyone sit down, keep the peace, and you'll get a payday at the end of this. We also try to keep in mind the age of the person that we're asking to do this. If we're saying, hey, my 5-year-old nephew here, I want him to get a payday on his birthday for the next 65 years. I'm not going to turn to my 65-year-old, relative and say, for the next 65 years, you're going to do this for me. The math just doesn't math. Now, we might start them off and have a backup, and we might start thinking through who's going to keep taking over this responsibility if that's truly what we want to happen. But we also have to be mindful of we're signing someone else up for a pretty big job, and that's the burden part, and we need to be cognizant of that. And so our role when we meet with you is figure out what are you trying to accomplish, but we are going to ask you to think about, is that the right ask? Is that the right way to do it? Is that putting too much of a burden on somebody? And if it's really what you want and that's a big burden to ask of a family member, well, now maybe we need to switch gears here and get more of an institutional approach involved. And we might need to find a different solution here where we have a corporate fiduciary come in, someone who's designed to outlive a human lifespan, and they just kind of start going through the next employee to kind of take this over and keep following the instructions that you've laid out. So there's always a solution. It's just a matter of getting to that right solution based on what your goals are. But we have a lot of tools available to us. Questions on that before I turn things back over to Ryan? Yes?
If you named a beneficiary in your trust, can you say, if you don't trust that, okay, I named my sister, and she's not bright enough to do this stuff, but I want her to be the beneficiary.
Yeah.
And I say that she has to go to Ryan and get help to do it.
If she's the beneficiary, are you giving the money directly to her, or you're worried about her not making good choices with it?
There's a plan for how it's supposed to be
Okay.
divvied up.
But you're putting her as not beneficiary. She's personal representative. She's the one in
She's both.
charge.
Okay,
Yes.
in both, okay.
Put her with someone else.
Yeah.
Have her.
That's the problem.
Correct. I know. But the predicament is putting someone who isn't going to be responsible and handle it the right way can still cause major problems and a lot of suspicions between beneficiaries. But you're with a lot of really good people who have a lot of struggles in what they do for beneficiary designation. Who to put in charge if they're also a beneficiary. It's a big struggle. Other questions on that? We were going to go back to one slide. This slide here. Go ahead, stick around. Have fun.
I'll switch spots with you.
Okay. When Amber was up here doing the slides on this area, she bypassed this to where we could get to it if we had time. We don't, so we're going to get to it anyway. So it is 3 o'clock, and if you need to duck out, feel free. I want to take a couple minutes because this is a very fun slide about controlling from the grave. So it also lends to be a lot of questions of creativity, and so that's why we try to come back to it sometimes. The issue is there is a lot of creativity that you can do for your beneficiaries. It's your money. An inheritance is a privilege, not a right. And so we talk about guardianship provisions if you have minor children or grandchildren or great-grandchildren. And so you want to make sure you have provisions in there that you're not giving $1 million to an 18-year-old and saying, oh, don't forget to go to school. Good luck. They call that the lottery syndrome. If you've heard about it, you understand what I just meant. But there's also what's called a testamentary, irrevocable trust. And this is what they were saying goes inside of your will or your living trust. If you're not doing it outright, you're using a testamentary, irrevocable trust. And this is any time you don't want to do it outright. I have one son who spends every dime he gets either on his son or on animals. Is there going to be any retirement accounts for him when he hits 60? Yeah, that's called my death. I don't really like that one. So because of that, if we were to die, I am not giving it outright to him. Because by the time he's 60, it'll also be gone. So we're holding it in a testamentary, irrevocable trust. Not because he's an irresponsible beneficiary, but he is. So This will allow the money to still be there at that time. And I can say he gets so much a month, so much a year, or I can say, you're in charge of the money, you figure out what his needs are, only meet those needs based on maintenance, education, support, and health. I get to choose. Certainly, as they were talked about earlier, you have situations like drug and alcohol. We've locked up millions of dollars in provisions when the beneficiary knew before the parent died. If he got involved in drugs or alcohol, his estate would be locked up. Still did it. Okay, went through 4 rehabs. Now we're able to release some money. Trust paid for the rehabs, but that was about it. So there are ways you can help accommodate situations your kids may or may not be in. Incentive trusts, I love. People have heard the term trust baby. They're waiting for mom or dad to die so they can live off the fat of the land. We've got a half a dozen or more that they feel their kids are waiting for that. So we put a very fun provision into the document. For every, it's in trust for their life. And for every $1 on your annual income tax return, you can have $1 from the trust. Just turn your tax return every year into the attorney. He'll compensate you. If you want to stay home and a spouse works, good, we'll match that too, instead. To a certain amount, maybe more, maybe less, probably not. We have those who go, you know what? When you're in 30s, this trust will give you $3,000 a month. When you're in your 40s, it'll give you $4,000 a month. When you're 50s, it'll give you $5,000 a month. If you hit 60 from there on, it's $6,000 a month. Okay. We've had those that say, we want you to still be working, so we're going to keep it in trust till you're 60, and we're going to make it a pension. In other words, when you reach 60, at 61, you'll get 120. 62, you'll get 119th, 118, 117, 116. Because an IRA can only go 10 years. We can make this go 20. We can make it go 30. Different ways people choose to do it. It'll stay there. You'll get $1,000 a month until it's gone, cost of living increase. You get 4% a year for the rest of your life, and then it'll go somewhere else. It's your money. It's your beneficiaries. What would you like? Special Needs Trust, very, very, very important tool. This is where you have children who need to be on government assistance. Autistic, Downs, accidents. You've got a children who is not going to be able to survive other than the government assistance they get. If they get a distribution outright or in a regular mesh trust, maintenance, education, support, they lose their government assistance. If you have ever gone through the process of helping someone get government assistance, you will never do anything to make them lose it. Because when the money is used up, they got to go through it all again to get it reapplied for. No one likes that. So be aware you can put a trust in place to take care of that. Dynasty trusts. What in the world is that? It just sort of sounds fancy. It is. It can go 150 years. Why? Why not become the family bank? Why should they get the money outright? How about if I put this here for multiple generations for education between 18 and 30? And additional, there can be a amount gifted or loaned out for paying for a down payment on a house with an interest rates that decided on by the family team that's now overseeing the trust. All sorts of different ways people have done it. The other thing of a dynasty trust is the family that has the family cabin over on Priest Lake, Idaho. I had a client who had that, and sure enough, every generation for 4 generations had enjoyed it. Problem is, by the 4th generation, and now it was owned by all these people, some of which used, some which didn't, all had to contribute, all had to pay taxes, all had to do, they had to sell it after 4 generations. You want to talk about tears? Because they never thought to put it in a dynasty trust and then fund it with life insurance. There's so much creativity that you can do for your beneficiaries if you want to. Or frankly, let it do it outright. I was with a client that said, look, by the age of 40, I'll give it some at 30, 35, 3 strikes, you're out. You get the last amount of 40, you screw it up and lose it all. That is not my fault. That is your fault. It's your beneficiaries. It's your money. And again, as Amber had alluded to, Pets, yes, Washington can do a pet trust. We're one of about 10 states. But we have some very, very poorly worded pet trusts. Up here's a dear friend of mine. So, you get to care for my pet, but when the pet dies, my friend's going to get the rest of the money because I'm going to put in about $50,000. Do not invite my friend over to your house. Oh, poor Fido. Got backed over a week after I died. Incredible how that happened. Birds can live 150 years. Tortoises, don't even go there. It doesn't have a vertebrae, you can't do it. Shell's not a vertebrae. You also have to be careful because I'm going to give you the ability to care for again, I get to pick on my friends.
That's okay.
They only come to my seminars once or twice after they go, enough of that, I'm sitting in the back row. That's not safe. There's another one of my friends back there. For as long as this pet is alive, you get $100 a month to take care of my pet.
Keep it alive.
That pet lived to be about 60. It changed colors, it changed breeds, but it was the same Fido the whole time.
How do you make sure those two scenarios don't happen?
Hire us. Because you set something in place that the person managing the money is not the person managing the pet. Second, you make sure that the person managing the pet doesn't get all the money when the pet dies. So you have someone who's like a trust protector watching over to make sure it's handled appropriately. There's other good tools you can do. There's a lot of creativity. Like I said, we love our jobs for a very good reason. Relatives. Yeah, you got to like them, but you got to be careful. For those of you who know my family, my mom's now 90. She'll be 91. I have an older brother, younger sister. We are the one helping take care of mom right now. If we die, who's taking care of mom? Oh, shoot. Okay, so we'll set money aside for mom if we die before she does. Great. But if I give it to her, wait a minute. When she dies, where does it go? Only 1/3 goes back to my sons. The other goes to my... Hold on. So I put a testamentary trust in place for my mom. Because when she dies, the rest of it goes where I say it goes. We had to do that for her sister. For those who know her sister, there's a reason for that too. But we want to make sure when Leanne dies, if she doesn't need it, it goes back to where we want it to go to. Then we have my niece and my nephew. Nah, we're just giving money outright. We love them. Sandy's the favorite aunt. They called to talk to her. Chopped liver. I don't know. Yeah, pretty creative. Other things, friends. And again, on relatives and friends and pets, we will ask you, what if they die? What if they're not alive at that time? Some people like their friends more than they like their relatives. Yeah, we won't go there today. But you have to decide, are there people you'd like to give something to and give it outright to them? Then no holds barred. It's there. Do whatever you want with it. Or you want control over it, then put restrictions on it. It's your money. But these are other creative things you can do. And last but not least is favorite causes. We have a lot of people that want to leave a legacy, so they use a DAF or they look to foundations within the organizations they like. We have others who go, look, I've given enough money during my life, I'm not doing it on my death. And others go, I don't want it to stop when I die. Here's a chunk of change. But what happens if that charity is not in existence? So you want to be looking at these things. These are just other creative things you can do with your money. And of all of you, stand up please. For all of you discussing whether this is important or not, look at her sweater. Pet trust. Okay. Thank you for coming. We're going to be around. Amber had to do something quick. She'll be down in a few minutes. We did go a little over, but I appreciate you being here. If you have questions, please ask us. If you'd like another handout, do that. If you would like to do a checkup, your clients of ours, or a new appointment, that's what Carol's over there, and Heather will be over there on the computers in case people want to get together just to talk about and apply this to you. And that's all. Yes, questions. We are going to stick around.
You mentioned earlier that, like power of attorney, you need some alternates. I never heard if there's any order to the alternates.
Okay.
This is number one alternate.
Yeah. Yep. The question was on a financial power of attorney, on a medical power of attorney, it's important to put alternates. What I forgot to say, so I'm really glad you asked, is you can also put multiple people together. You may have a situation with your kids where one tends to steamroll the other, so you put them together as and, that way they both have to give their opinion. But the more common one, especially on a medical power of attorney, is and. I'm putting both of you on together. First one there, try to get over the other, but make the decision. Don't let me die because you couldn't reach the right one. As to the alternates, I've had before where they put these two together, the survivor, then these two together, then the survivor. I've had these two together, but if one can't, this one steps up as an alternate. It's up to you, but you definitely want to make sure yours does have someone. There's backups. And the order is whatever you'd like it to be, because that's what we'll ask you. Good question. Any other questions? Okay, we're here.
Should we talk to you about a checkup?
Oh yeah, they don't let me touch the calendar. They know better.
Thank you, this is great.
Thanks for being here, guys.